Now in this session, we will consider the two new concepts that are the LLP and company, one person company, which has been enacted by the statute. LLP has been started as per the Act 2008 and OCP has been formed as per Company Act 2013. There are two distinguished legal persons has been born by the statute. Now let us will consider one by one. First, LLP 2008. This is the hybrid combination of provisions of the Company Act and the Partnership Act. It gets some benefits as per Company Act and some benefits as per Partnership Act. You are aware that in Partnership Act, the partner's liability is exhaustive. So there is no upper limit for their liabilities. But in as per this act, the partnership which has got the limited liability. So it has been named as Limited Liability Partnership Act. It is separate from partnership, means individual partner. In partnership, there is no separation between the partners and the partnership. Here, in this, as per LLP being a legal person, different entity can enter into a contract and can hold the properties. This facility was not available in the Partnership Act. Then partners' liability is limited to their agreed terms. This is not so in the Partnership Act. Here in LLP, the professionals and non-professionals, that both can set up the LLP. And the formation of LLP, the main object is that the formation of LLP should be for the making profit only, no society services. LLP cannot be formed as a NGO. Society services, social obligations, or nothing, only profit. The aim of the formation of LLP should be a profit only. Then what will be the duration of this new entity? The new duration of LLP may be perpetual, means forever. Just like company, unless it is winded up, same thing. The LLP can be winded up with observing certain rules and regulation. Otherwise, it is a perpetual. Then, what will be the object? It may be formed for the specific event. What may be the event? Let us, somebody has arranged an entertainment show, and for that LLP has been formed, for that incurring a expenditure and making in the account and all these arrangements. When that function is over, the LLP stop. The duration of that LLP to just perform that specific function, entertainment function. Then it may be for the specific job. Now you are now witnessing a redevelopment projects across the country. The LLP is formed for construction of particular society's redevelopment project. So the object of formation of that LLP is to construct the building, new building. When new building is completed, OC is obtained, possession is handed over to the resident, original resident or society. Then the purpose is over, the LLP ceased to be operation. Then if there is no specific duration not specified in the agreement, then it will be the perpetual. And whatever is object, whatever their clause, that must be specified in the agreement, which is called LLP agreement. Then what will be the main feature of agreement? Objective, ways of achieving that object, means to be collected, how to perform. Each and every thing has been incorporated. Then there some technical terms used in the LLP agreement. Then definition and interpretation of that word or that phrase should be incorporated in the agreement. On the receipt of LLP certificate from registrar, it is start the commencement of business. It governed by LLP Act 2008. Registration for ROC is required. It is created by law. It is separate entity from the partners. The LLP firm can sue to other person in his name or can be sued by the other persons on, on this firm different from the partners. Then there is main feature of this, that when any name is suggested, then the word LLP should be suffixed to that account. Say A and B avocation is the firm, which is LLP. Then A and B avocation LLP. That LLP word should be suffixed, so the public as a large came to know that this firm is a limited liability firm. So after registration, on receipt of commencement of business certificate, the firm start their function. In this LLP, being a LLP is the separate entity, many partners can come into it or make some withdrawal. In this LLP agreement, the contribution of each and every partner must be specified. His liability is always specified. But that not in the case of partnership act. If one person resigns, put up his paper or resign from the partnership, or if there is a death of the partnership, that as per only partnership act, the account should be seized. Is establish that activity or partnership firm's name is to be seized. He cannot continue with the same name if otherwise is specified in that particular partnership deed. But Partnership Act does not provide this. On resignation of partner or death of one partner, partnership firm as per Partnership Act gets dissolved. But that is not the case in case of LLP. Then in Partnership Act, it is the combination of Company Act and Partnership Act. So we'll discuss side by side these features. In Partnership Act, each partner is the agent of all partners, but that is not the case in LLP. In LLP, there are working partners. There are two working partners needs to be specified in this LLP form. Then in that there must be minimum two partners and maximum no limit. But that LLP firm should appoint two partners who are authorized to function and responsible for the all affairs of that LLP, and that should be incorporated in the agreement, who are be the two partners. So here there must be minimum two partners, maximum any number. In Partnership Act, minimum two partners. If the partners number is exceed 20, then it becomes illegal association. So that is not the case in LLP. In Partnership Act, the partners has to contribute by cash, by our funds, but in LLP it is not required. Any partner who are combining and forming LLP can contribute as per project. So one partner who has got funds, he can contribute by investing his cash. Another partner who has got very good technical knowledge regarding the project and have capacity to perform it, he can contribute by his knowledge. Third person, say, who is very much influential in the society and respected in the society. So he can, by his giving name as a partner in the LLP, can he become a partner. There is no need that he should invest a single rupee in that firm. So in LLP, partners can combine by contributing by cash or in kind. Then in the agreement, all the partners' duties and powers and authorities are specifically incorporated. And also their shares in capital and profit and loss is also specified in original agreement. which is to be submitted to the register. It is different from partnership in that angle. Then, while submitting the paper for registration, one has to give the copy of LLP agreement, all documents, details of partners, their account, their statement of solvency, annual return file by LLP with ROC will be available for public. So whatever the documents which are submitted to the register are the public document, and all the affairs and information of that LLP is available with ROC, and anybody can collect that information by paying prescribed fee. That is not in the case of partnership act. That this disclosure in partnership firm is there. Partners were not disclosing their affairs to the public in large. Then now the LLP has been exist with all these expressions. LLP can be wound up voluntarily. Earlier said, if specific purpose is accomplished, the specific project is completed, or otherwise, if it is executed in ongoing process, means ongoing business, then if the market situation has been changed, just like company can be wound up by applying to company board, law board, same way LLP can be wound up voluntarily, or just as the company which unable to pay to their creditors, then some creditor sued or applied for winding up the company. The same thing is to approach the court for dissolution of winding up of LLP firm. In LLP firm, the agreement is the main document. Just as in company, memorandum and article of association is the main document, and company is operated by managing director and board of director. Same way in LLP, two partners are designated. They are operating the firm. Then just as company, even though there is a manual signature in some of the documents, we need the company seal on documentation. The same way it needs in documentation the LLP seal. Just as in company where foreigners get invested, they invest in Indian company. Same way, the foreign partner can be incorporated in LLP, but there must be minimum two partners which are Indian. Then LLP is independent of partners, as already explained. Partners are liable whatever up to the contribution or whatever the terms and condition has been specified in LLP Act, except In intentional form, the liability of all partners become exhaustive. Means each and every partner's liability is exhaustive, such as provisions in Partnership Act. In Partnership Act, partners are jointly and severally liable. That clause is applicable if there is a fraudulent transaction made by LLP, then this clause will be applicable. And liability may be extended by international fraud or wrongful act of omission and commission, or acting beyond the powers delegated by the agreement or act specified in the agreement. In Partnership Act, each partner is the agent of another partner, that you aware of. Then, as per LLP, the partners are not the agent of another partner. Partners are responsible to the LLP, being distinct identity. If partner make any act which is contraventional to the agreement, then he is liable to the LLP firm. Then partner can be seized voluntarily, giving due notice to the firm that I am withdrawing. In that sense, company may adopt another partner or function within the existing partner. But in partnership firm, the firm has to be dissolved and new partnership firm has to be formed. That is not the case. So the LLP firm is distinct from the partners, having separate identity, separate legal rights. This is the basic of main difference between the LLP and partnership firm. Another, if you feel that there is an ongoing concern, there is some partnership account which is ongoing, then if their capital exceeds 25 lakh of rupees and turnover in last 3 preceding years exceeds the 40 lakhs of rupees, then that firm can be applied for registration under LLP Act. Whatever earlier we have discussed the formation LLP, if you wish to form a new LLP, then minimum capital is 1 lakh is sufficient. But in ongoing concern, there may be some account which is ongoing, functioning as a partnership firm for last 2-3 years. If this condition is satisfied, that their capital is increased up to more than 25 lakhs and turnover in last 3 years exceeds 40 lakhs, the normal partnership firm can be converted into LLP firm. So, and another thing, that Being a LLP is different entity. The partners are different from firm. There are two partners which has been appointed as per statute. They should apply with central government, and for that particular LLP, the DPIN, that is distinguished number, is allotted to that persons. So after receiving of DPIN, distinguished number, all the affairs and transaction which is required to be signed by the firm has to be signed by DPIN. So in company there are directors, they delegate authority on them. So for operational purpose only, the agreement must specify the names for who will operate the account on behalf of LLP. In partnership firm, though out of 5 partners, usually 2 partners were operating the account. But if we get a written notice or letter from the another partner regarding the stoppage of account, then being a partner, we have to follow that instruction. We should not say that account is operated by some another 2 persons and remaining 2 or 3 partners don't have authority in respect of operation in the account. But that is not in case in this LLP. Being the LLP is the separate entity, the operation authority has been delegated to the certain means minimum 2 persons who has got the DPIN. They and they only transact on behalf of firm, LLP firm. If there is any letters or notice from other partner, we should send this notice or letters to the firm as a precaution, because agreement may have provided some clauses regarding this aspect also, or may not have. In absence of contrary, if there is no mention of any act, then it is necessary to approach the LLP firm, that firm, because being separate entity. And in other cases, even they are the partners of LLP, for dealing with the LLP firm, they are third person in bank point of view. So if you sanction any credit facility of the LLP account, then documentation of that account should be as per the documentation of the company, and you must take all partners as a guarantor to save the bank's interest. So in agreement, there may not be liability of the partners, may be limited, but if you taken individual partners as a guarantor or surety, then their liability is not limited to that advances that limited share, I mean say that limited share. There may be 5 partners are there. As per agreement, their contribution for profit and everything may be 20% liability of the firm. If liability is more, and means that liability is proportionate to capital. In LLP's liability is restricted up to LLP's capital. So there is a capital of 40 lakhs and bank's finance say it is 50 lakhs. Then for LLP their liability is 40% and contribution from that 5 partners will be 8 lakhs each. But if you have taken them as a guarantor, then it will take care of excess amount of 40 lakhs. So if there are 50 lakhs each amount, then that 10 lakhs of rupees you will be legally recover from any of the partner or all of the partners, being a guarantor, but not as a partner. So I tried to distinguish this legal entity, a hybrid of Company and Partnership Act with a new statute as per 2008 Act LLP. If you have got any problem, you may ask. One point has been skipped, that is LLP can purchase any asset in his own name and all that asset can be the property of LLP firm. The individual partners do not have any interest in that assets, property, rights, what has been acquired. So the LLP firm can offer the security which has been purchased or created in firm's name. That was the point. In partnership, that is not the case. Now we will consider another type made by statute 2013. It is a combination of provisions of company and say proprietor firm. In proprietor firm account, proprietor is not separate from the firm in respect of all dealings, but that is not the case. In company, we know that there are number of shareholders, means the shareholders stake and is not controlled by number. So this one person company is a new entity for individual for carrying out the business as a corporate with limited liability. It is a one person company, means one person, one shareholder, but distinguished from company. Means if I am the person, I form the OPC with name, say AB and Company. AB and Company is separate thing and myself is the separate. And I will be the only shareholder in that company. But as a person, I am separate from that company. Understood? In proprietor firm, the proprietor firm and proprietor are not separated. They have got the same identity. But in OPC, this is not so. Then OPC can be registered as a private company. Private, don't get confused with private limited company and private company. It is a private company. It is not limited company. Then for formation of OCP, OPC, you have to follow all procedures such as formation of company. OPC can be formed with minimum share capital of 1 lakh of rupees. The shares cannot be transferred in another's name. In company, the shares are transferable, but in OPC, the shares are not transferable. Then, in limited company, other public, the company can raise the capital from the public at a large for their project, but that is not the case in OPC. OPC cannot call the capital from public at a large. That whatever the capital has been impounded or infused in company, that must be that one person's who is forming company his own money. Then for formation of OPC, he has to prepare memorandum of an article of association of subscriber. He has to prepare that one. And another thing, the main person who is forming OPC has to prescribe or name one person in that memorandum who will transact the company's affairs in case of incapability or death of person. So the OPC must have a perpetual life. So it is just like a succession and it's called a nomination. But whom the person is nominating, that person must give written consent for that. That is the main condition of nomination. In usual course, what we observe in our deposits account, that account holder nominates some person, there will not get the consent or will not insist for the consent of that person, but not in this OPC. There must be a written consent from person who has nominated. Then just we have earlier observed that partnership firm must have the suffix of LLP. In the same case, this the title of account must have a suffix OPC Limited, and that is the must thing. Then another restriction: the one person cannot form more than one OPC. Then also the person who is nominated cannot acquire the nomination in other firm or become a one owner of other OPC. Same way, the person who is forming OPC cannot become a nominee of other OPC. So for all the times, still that account or company is in existence, there must be only one person. Then there are restrictions for formation of nominee. Nominee should be a major person. Minor cannot be nominated, nor minor can be adopted for the benefits of company. In partnership or proprietorship, in partnership firm, the minor can be adopted for the benefits only, that we know. But in OPC, minor is not allowed to acquire any interest or become a member or nominee in the firm. Then mandate well, it is private limited company. So if OPC is required to be converted into a private company, there is a locking period of 2 years. After 2 years, without any uh, you may say rider, without any riders, it can form the another type as a private limited company. But if it is a OPC, if you wish to convert in the private limited company, then there are two riders. And what are the riders? From starting business, the company capitals exceed 50 lakh of rupees and an annual turnover exceeds 2 crores. After achieving these riders, the OPC can be converted into private limited company even though within 2 years. So if the person has started his business, on his first order he get a windfall gain of that order and increase end of first year by appropriation of profit, his original capital what was started with, he is exceeding 50 lakhs of rupees, and his orders turnover means that order amount is exceeding 2 crores of rupees. Then Even after completion of 1 year, that OPC can be converted into private limited company. Then there are some types of OPC. A company limited by shares only, or company's objective is to give guarantee, then that guarantee, suppose I want to give guarantee for a loan of B, a person B. If I give guarantee for B as an individual capacity, then my liability is not restricted, being a surety. So what I will do, I will form a OPC, and that OPC will give guarantee to that B. So my liability will be limited to OPC's capital. So this is the way, also one limited way to give guarantee and for formation of OPC. And it is a maybe unlimited company also. OPC is the one person, guarantee may be limited or unlimited. The company is giving guarantee, others are accepting. Let it be. It is separate entity from person. Liability is limited. In it is here. The liability of debt is not personal. Payment of debt, responsibility of payment is of the company, being a distinguished person. Then for finance, just like operation of the account, we have to watch the operation of company. Then also being a legal person, the OPC needs to register as a separate entity for all income tax, all tax purposes. Same way, if we finance, the information is available, because when OPC is registered with the company, all the papers are became public document, and on payment of prescribed fees, the information available to the public at large. OPC can purchase assets by his own name, distinguished from the person. It can charge or create charges on its assets, being company's assets. Then this memorandum, the procedure part, let we see. We have formed the OPC. Memorandum and article of association has been submitted to the company. That time we have nominated one person. His written consent has also been acquired and submitted to the company. Then registrar of companies give name, and then it is said that your company is registered. All your assets and information has to be registered with ROC. It is to be with ROC. Then another thing, that if nominee desires after some period that he don't want to remain as a nominee or successor, we may say. They, for his willingness, he should give a written notice to the company, not for that one person. He should write a letter to the company, copy to the registrar. On receipt of letter of withdrawal of nominee, within 15 days, the company should appoint another nominee on receiving his recent consent, and whatever the formality has to be complied with, and submit to the registrar. In between period, a shrewd banker should keep hold on this account, because on the moment the second person nominee is accepted, the earlier person gets absolved from all liabilities. So this portion, be cautious while dealing with the OPC. Then whatever the assets has been created, the charges should be registered with the ROC, and the copy at same procedure as a private limited company. Then ROC get the certificate. The company should also submit his account after completion of year to the ROC, and it is made available to the public at a large. Then what is OPC? What are there? It is a private limited company. Who can form OPC? The Indian resident can form OPC. Who is Indian resident? Who resides in India more than 180 days. He should not be NRI or foreign citizens. Only the Indian citizens can form OCP. Then if he wants to convert this into limited company as a private limited company, then members should be with more than 50 to 100. 200 can be formed as a limited. Shares also be transferable. Then they delegate in OCP the powers. So 10 crores are the minimum. If company 10 crores is the, we may say, solvency must be there. Public can file a suit against OCP just as got other cases. Company can also sue other persons on his own name. ROC is the compulsory. Whatever the provisions are applicable to the private limited company are applicable to the OPC. Then accounts should be audited. Audit report should be submitted with ROC within that prescribing. Then On resolution, loans to the director can be given as the same. It can be a holding company of subsidiary company, whatever private limited company's business is there, and any changes in the terms and condition should be incorporated in the MOA and AOA of company and should be informed to the register. If there is any agreements with that company regarding that business, that should be registered with ROC. If there is any unwritten agreement, then on within the 15 days from formation of agreement, mean oral agreement, if oral contract we are talking about, when a oral contract is made, then within 15 days it should be minutized in the meeting of directors, and copy of that minutized meeting should be sent to ROC. So OPC can make oral contracts or as well as written agreements. When there are the agreements, copy should be filed with ROC. If there are oral, then within 15 days it should be copy of that minutes of meeting should be filed with ROC. And for that, every meeting a register should be maintained and that should be available for inspection. That the one person who has got share in his name, he is the managing director. Considering the company's affairs, he can appoint directors as per his needs. So there will be board of director also in the OPC also, one person company also. There will be regular meeting of the directors also. It should be minutized and copy of the minutes should be filed with ROC. Just like in private company, here the company has to fulfill the other objective also, that is CSR. 2% of average net profits of last 3 years to be mandatory spent of CSR of company. But this is applicable when OCP his net worth is more than 500 crores or turnover in the account is more than 100 crores or net profit is 5 crore or more. In small OPCs, it is not mandatory. So main feature of OPC and a proprietorship account are provisions are very much similar or functions are also very much similar, but proprietor firm is not separated from the proprietor. Here OPC is different from the person who is forming company. Then for documentation, if you finance any OPC, charge your all assets of the OPC assets, and also take the person as a personal guarantor. That will protect much of the things which may occur in recovering bank's dues. So all the best for your examination.